Remove me off the network!
Please call the case.
This is case 21-MJ-14, United States of America versus Anthony Joseph Gionette. This is scheduled to be a status hearing held by video. Will the parties please introduce themselves to the court, beginning with the government?
Good afternoon, Your Honor. AUSA Christopher Brown for the government.
Good afternoon, Your Honor. Joseph Scorfano, local counsel on behalf of Mr. Gionette.
And Arizona Counsel Attorney Zach Thornley on behalf of Anton Gionette, who is also present, sitting next to me, Your Honor.
Good afternoon, Your Honor. John Copes, Pretrial Services.
Good afternoon, Your Honor. Officer Rebecca Teach with Pretrial Services at the Federal Courthouse in Phoenix.
Good afternoon. We're here because pretrial has submitted a series of reports. I hope the parties have seen, I think there's 2 of them. So I hope everyone's seen both. I have. Raising some concerns about Mr. Gionette's behavior while on release in this case, suggesting that his conditions of release should be modified to include home detention, notification of any contacts with law enforcement to pretrial services, and to not possess any firearms or other dangerous weapons. So I will hear from pretrial. It's your application. Go right ahead. Whoever wants to speak, perhaps the pretrial services officer from Arizona who knows the most should address the court.
Certainly, Your Honor. I have not seen the reports that have been filed with the court. We're providing courtesy supervision for the charging district there in D.C. Is there anything specific you have questions about?
No, I mean, to you, maybe it's Mr. Copes. Are you the one who's requesting that Mr. Gionette's conditions of release be changed?
John Copes, Pretrial Services. Yes, Your Honor. PSA, Pretrial Services Agency for the District of Columbia is requesting that the modification in the defendant's release conditions due to the information provided by the Arizona Pretrial Office. The defendant has made several contacts with, while under courtesy supervision in Arizona, has made several contacts within the past 10 days with law enforcement in Arizona, to include Mesa Police Department. The defendant's behavior is concerning at this time, and I will kind of break down the reason for each request in the defendant's modification. Defendant at this time does not have to report as soon as possible to Pretrial Services Office or supervising officer every contact with law enforcement personnel, including arrest, questioning, or traffic stops. In light of what's been occurring in Arizona, PSA is making the request that the defendant report those contacts with law enforcement due to the defendant having multiple contacts with law enforcement within the past 10 days. The defendant, it is a national standard that when someone is being courtesy supervised from our office to an office for the United States Probation or Pretrial Office, that the defendant does not possess a firearm, destructive device, or other weapon. At this time, the defendant's release conditions consist of a defendant to not illegally possess any firearms. We believe that there is a safety issue due to the defendant's recent behavior and what he has shown on video, that there may be a concern for officer safety in that if there is a need to visit the home of the defendant, PSA was requesting that the defendant does not possess a firearm, destructive device, or other weapon due to a concern for the safety of the supervising officer. in Arizona, officers. The defendant has made, initially when the defendant was released, the defendant was placed on location monitoring. And since that time, the defendant was taken off of location monitoring, I believe, on March 31st of this year. Due to the defendant's recent contacts, to include after the 10 o'clock hour, and to include, while the defendant has been off of electronic monitoring, location monitoring, the defendant has had these contacts to include the defendant appearing to give threats to an individual, defendant being in what appears to be agitating situations, and having those during those multiple contacts with law enforcement. The defendant has also been trespassed, barred from going to a Starbucks in Arizona for approximately 1 year as well. And so PSA feels as if with the support of the Arizona pretrial office, it is the recommendation that the defendant be placed back on location monitoring so that he may be monitored while he is in the community. It appears not only from his contacts, but what is shown on a video that has been provided to the court, that the defendant appears to be a potential danger to the community, and this behavior that has been shown on the posted YouTube video, which brings me to the defendant's modification of not posting videos to any social media website to include video sharing platforms. It appears that the defendant is out in the community as a video YouTuber, individual that posts videos, live videos, and it appears that the defendant, being a part of the video sharing platform, being part of recording and posting these videos, it appears that during these incidents that this has the defendant being a part of these situations that seem to escalate from being what is supposed to be something that's as the defendant may express, something that is consistent with what is a YouTuber or so, seems to escalate into law enforcement or multiple law enforcement contacts that consist of situations that escalate while he is out in the community. So PSA requests that those following modifications that are also listed in the two reports that were submitted, one that was submitted on May 28th and the other that was submitted earlier today, that the defendant PSA requested those modifications of the defendant's release conditions.
Mr. Copes, you mentioned the defendant doing something after 10 p.m. at night. Does he have a curfew?
The defendant does not have a curfew. I noted that due to the request for GPS monitoring in the hour of night that some of these incidents occurred.
Mr. Copes, is anything in the report or either of the reports you submitted, does anything he did reflect a violation of his present conditions of release?
No, Your
If
Honor.
I may, pretrial services in the District of Arizona would be happy to answer that question if you're inclined.
Go right ahead.
Thank you, Your Honor. The District of Arizona initially reached out to Officer Copes because the defendant was having such frequent negative law enforcement contact. And initially, when we reached out to the officer in the charging district, we acknowledged that these police contacts were not a direct violation of his conditions of release, but did appear to be very concerning for safety of the community. In the videos that the defendant has posted, and one he posted and I believe took down immediately after, but one I think has been submitted for the court to review, it's clear to see his exploitation of the people around him in these videos, people known to him and unknown to him, and that his attempts are specifically to agitate, anger, and offend and provoke a violent response to then video during live stream for people to continue to comment on throughout the live stream for people watching from different, viewing sources, out and about. And we just had concerns for safety of the community as this behavior continues to go on at such a fast rate. He had 3 negative law enforcement contacts in the span of 6 days. 2 of those law enforcement contacts lasted throughout the night and involved more than 1 police department having to respond. And in the video, which I believe Your Honor can see, the defendant is not showing himself, but he's in fact showing Mesa Police Department officers who are responding to these scenes, and he's playing songs for them and singing to them, and again attempting to evoke anger and frustration from local police departments as well as other law enforcement agencies that respond throughout that area. In Tempe, Arizona, there are several law enforcement agencies. Just for the point of clarification, there's Tempe Police Department and other Tempe authorities are their title, and those officers, they're tasked with just keeping the peace around a large college town, and the defendant has had contact with that law enforcement authority as well. So that is why we initially reached out to Officer Copes in an attempt to minimize this risk to the community that the defendant continues to present.
Okay, Mr. Brown, the government position.
Yes, Your Honor. The government concurs in the recommendation of pretrial services. And I think it's important to note that no party here, Your Honor, is seeking to revoke the defendant's pretrial release. What pretrial services is asking for, and what the government agrees, is an adjustment in his conditions of release, because this court is required to consider any condition or combination of conditions that, among other things, will reasonably assure the safety of any other person and the community. And I think that it is clear that the defendant's conduct, while possibly on the line of committing an actual crime, certainly rises to the level of a clear nuisance. There's an unsavory pattern to these interactions with law enforcement. And I do want to point out, Your Honor, that in that video that was shared with the court, the defendant does arguably, there are moments where the defendant himself arguably commits assault and battery. The defendant engages in fighting words. I won't read everything, but he does tell his friend, "You're a effing bitch, why don't you fight me like a real man? You're a effing pussy dude. You effing bitch, you dumb bitch dude, you're a pedophile." The defendant then lunges towards his friend and has to be separated from his friend by the other friend, the one who was driving the car. It's also significant, Your Honor, that in the police report, the police actually considered arresting the defendant during his second interaction with law enforcement on that first night for disorderly conduct due to, quote, his combative behavior and words. Now, I'm not sure if, I know the defendant has not been charged, and it is arguable whether these are actual violations of state or federal law, but it certainly rises to the level of something that should trigger this court's concern in tailoring more restrictive conditions to govern the conditions the defendant's pretrial release.
Let me ask the pretrial services officer from Arizona, you are doing courtesy supervision, is that correct, of this defendant?
That is correct, Your Honor.
And then, do you do home visits in Arizona? I don't know what your practice is out there. Do you ever go to the defendant's home?
We do. Due to the COVID-19 health pandemic, we have changed our in-district policies regarding in-home contacts. But should the court be inclined to have more frequent in-home contacts with the defendant, we can do that.
Okay, so that means during the pandemic, you've not been visiting this defendant's home. Is that correct?
I believe when he was on location monitoring, he did have officers at his home more frequently, but once he was removed from location monitoring, he came to my caseload as a generalist that supervises cases that would not require any special monitoring, like location monitoring or specific mental health treatment cases. So given when he was reduced to my caseload, I would say it was a reduction in supervision when he came off of location monitoring. A home visit has not been completed since that time. And I believe that's been about 2 months.
Okay. Hear from counsel to the defendant.
Your Honor, I believe that, well, I don't believe, it's undisputed that there's not been any violation of Mr. Giannett's release conditions. I want to address just some of the things that were discussed. Mr. Cope mentioned that it's a national standard not to possess a firearm. It may be, but Mr. Giannett had not had a firearm restriction since the beginning of this case. I don't know, nothing in any of this has anything to do with the firearm, including the charges that he faces there in DC. I'm not sure exactly what the concern is for a firearm. He's never been accused of misusing a firearm or using a firearm in any kind of crime. In fact, he does have a firearm, but it's not even at his house. He removed it just out of pure concern of not wanting to get in any trouble or to violate anything, even though there's no restriction that he not have a firearm. The mentioning of the negative police contacts is concerning for me as a defense attorney, and specifically in regards to what has been requested here or what's been proffered to the court on the part of probation. It's concerning to me because it's completely untrue. The contacts that he had were because he contacted police himself after his friend had hit him. And that was it. I believe other than I think there was a mention of a trespass from a Starbucks. And in that case, as soon as he was told that he couldn't go into Starbucks or that he couldn't stay in there, he left. After he left, he was standing out.
I thought he was barred, meaning he went in, he played some song, offensive song, and then they said he can't come back.
That's exactly right.
So now if he were to go back, well, that might be trespass. But right now he's just been barred because of whatever you want to call it, offensive conduct.
That's exactly right, Your Honor. So other than that, he was the one that made contact with officers. He told officers what was going on, that his friend had hit him. That night, and I'm kind of rehashing what's already in, some of the responses back from myself and I don't know if the state touched on it, but or the government, but Mr. Giannett doesn't drink. He doesn't drink alcohol. He doesn't do drugs. He's completely drug-free. He's alcohol-free. The driver of the vehicle that night does not drink. There was no drinking involved from either Mr. Giannett or the driver. The only person that was drinking was the person that he ended up calling the cops on, who had actually hit him. That was the only person that was drinking. I just find it extremely concerning that because someone may be offended by his behavior or what he does or what he likes to do for work or for making money, that we're going to get hauled in to account for these things. And then on top of that, there's a request to modify his conditions of release, which I believe wholeheartedly would be a direct violation of due process. And I believe as such because, again, there's no dispute that he didn't violate any conditions of release. And I think that modifying anything based upon the fact that he didn't violate anything violates his due process rights. And again, as I mentioned in my response, if he does violate something, at that time, the court has all the power to completely punish him or to have him held accountable for whatever actions it is that he takes that he is not supposed to do. But it's completely incorrect to hold him to a standard that was not even in place or that's not part of his release conditions. It's really actually really ridiculous in my opinion. I do want to address a couple of things in regards to questions that the court had for probation, which is whether or not there was any home visit. Your Honor, in regards to his prior probation officer, Mr. Justin Lauby, I don't know if I pronounced that correctly, but he made visits twice a month, every month. He made a total of 10 visits to Mr. Giannette's home. There was never an issue, ever an issue. The new probation officer has never visited his home since then. And so, I mean, we're talking about both probation officers throughout the entire duration of, within the pandemic. So this is not something that was outside of the pandemic. So I think if there was concerns about his behavior or safety to the public, that maybe there would have been more visits to his house or something along those lines to, I guess, check in on him for whatever reasons. I guess probation has the right to do so. So if there was concerns about his safety, they could have easily went in, checked his house, checked to see if everything's legit or if everything's cool, if he's behaving, if he's abiding by the guidelines of the release conditions that are set forth for him. But that's never been done with the new probation officer. And I would submit that there's a reason for that. And the reason is that there's not been a concern. If there was, she had every right to go follow through with that. The allegations that he is having contact with law enforcement, well, it's not illegal to have contact with law enforcement. For him, it would be a bad thing, obviously, if he's arrested, and he knows that it means bad things for him if he is. And if he is, then he will account for that at such a time. But it is not illegal for him to, and by the way, I feel like that this request is almost a message to him not to ever contact law enforcement if he needs to contact law enforcement. And Mr. Giannette has fans, but he also has enemies. And I think it would be a real detriment if he felt like he could not contact law enforcement when he needed to, for fear that he's going to be hauled before the court to account for that contact with law enforcement. With all that said, Your Honor, I also would rest on the arguments that I had submitted in my response. I don't know if Mr. Scrifano would like to say a few words as well.
Mr. Thornley, I have a question for you. Does he have a job, or is his job making these videos?
That is his job, Your Honor, and he can speak to that more clearly than I can.
I don't need him to talk. I would just want to know. I mean, the request here is that I prohibit him from making YouTube videos.
Yeah.
I don't know how that would impact his livelihood.
That's it. It's my income. It would cut off all of his income. That's how he makes all of his income. That's how, and that's what I was mentioning in my response. This is something he's done for years. This isn't something like he just started doing out of the blue, that he's like, hey, let me take up this new thing and it seems fun to do or something. It's not something that's a fun thing, or, well, I don't know, maybe it's fun, but it's how he makes his money. And he's done so for years. And how many years? When did you start working for BuzzFeed?
5, 6 years ago.
Okay, so he's done it for quite a while, Your Honor, and it's been the same thing that he's done since that time, right? Have you had anything? So yes, the request to cut him off from that would be detrimental to him being able to earn a living.
Okay, anything further from other defense counsel?
No, Your Honor.
The government, any response?
Your Honor, just a couple points regarding the defendant's ability to look to his own safety by calling law enforcement when he feels himself in danger. The defendant absolutely should feel free to call the police if he is in danger. He should do that. We hope he does. I would just point out in this situation, the fact that he filmed the entire encounter both times and monetized it by putting it up on YouTube. And in fact, during the video encounter or after the video encounter with police, but while still on camera, he admitted that it was a mistake to call law enforcement. I think that all goes to the point that this was not a situation where the defendant legitimately felt himself to be in danger. It was a situation where the defendant was trying to create viral content, and it creates a great deal of drama to have unwitting law enforcement personnel be, if you will, extras in the defendant's own narrative. With respect to the alcohol issue, after reviewing the video, the government agrees the defendant does not appear to be inebriated. I would point out, however, Your Honor, the defendant's friend, whom the defendant believes was inebriated, towards the end of the video, that friend comes over to the defendant's house, asks, "Hey, the cops don't know what kind of car I drive, do they? Did you tell them by any chance?" The defendant says no. The clear implication is that this friend who is drunk is going to go out in his car, and he wants to make sure that the defendant didn't tell the cops what kind of car the drunk friend drives. And then the defendant offers him a Steel Reserve, which is a malt liquor, if you aren't familiar, from the defendant's own refrigerator. And then later on in the video giggles with his other friend that first friend went out, quote, wasted in his own car. So even if the defendant himself were not inebriated, he's clearly abetting someone else's drunk driving, in addition to all of the other, and defense counsel has not addressed the defendant's own conduct in that video. The police officers believe the defendant was acting as an instigator, and I think you can trust your own two eyes in watching that video, watching the defendant bait and engage in fighting words, and at one point lunge at his friend. This is not a situation where I think we need to worry about were the standards of conduct clear ahead of time. The standard of not engaging in assault and battery, the standard of not engaging in egging on a friend to drink and drive, those standards are clear, and they were included in his conditions of release. And we're not asking for him to be revoked and sent to jail. We're asking for the court to adjust his conditions of release to reasonably assure the safety of the community.
Okay, anything further? Mr. Thornley, just to that last point about aiding and abetting his friend drunk drive?
Yes, Your Honor. I believe that's completely untrue. The reason why I feel that way, Your Honor, is that when they were originally stopped with police, Mr. Giannett is the one who informed officers that it was his friend who had been drinking and could not drive. Obviously they had both as I already mentioned, Mr. Giannett and the driver were both sober. So I don't think that by any stretch of the imagination, Mr. Giannett is okay with drinking and driving. They didn't put the drunk guy behind the wheel that night. When his friend came back to the house, I think there was still a question of whether or not he was going to stay. And so whether or not he offered him a Steel Reserve, in my opinion, has no bearing on any of these issues. It doesn't mean the guy was going to open it up if he was. First of all, and second of all, if he was going to stay there, who cares if he offered him a still reserve and the guy continues to drink? And additionally, and probably more importantly than anything, Mr. Giannette is not responsible for someone getting behind the wheel of their car after drinking and then driving, unless it's he himself who does such an action. So I think that I think it's disingenuous to try to hold him accountable for what this other drunk individual was doing or did do. The government mentioned something about that I hadn't addressed his own conduct that night. That may be partially correct, but the reason why I didn't address the majority of what they've discussed, what probation and the government has discussed, is because of two things. First, his conduct was not illegal that night. And secondly, there was no violation of the release conditions. Once again, I feel like a broken record, but I don't know what I need to address in regards to his conduct, because there was no violation. He's the one that called the cops. Nobody called the cops on him. So I don't know why. Again, I really don't know why we're all here today.
Well, we're all here because your client recorded all of it and put it up on YouTube, which a smart person might wonder if that's what you should be doing while you're under court supervision. It's the rare case that we can sit and talk about moment to moment what you did and what you said. We can only do it here because you recorded all of it and put it up on the internet. I did see the 30-minute video. I thought it was inane. I did not see a violation of your conditions of release. You came close to committing crimes, but I didn't see that either. Nevertheless, the conduct that is of most concern to pretrial is also concern to this court, which is that the conduct that night where you were essentially baiting your friend or whoever that other individual was, which led to assaults while you're inside of a car. I mean, you knew what you were doing. Putting the camera in his face, filming him, saying the things that you were saying to him. You wanted to get a rise out of him, and you did. And you knew that he would respond in a violent way, certainly the second time, and you did it again. And a moving car, that's dangerous conduct. So this is what I'm going to do. I am going to grant, in part, pretrial's request. You are going to have additional conditions of your release. First, that you will report as soon as possible to pretrial services officer, the supervising officer, every contact with law enforcement personnel, including arrest, questioning, or traffic stop. It really is a fairly standard condition of release, as is the next one, which I'm going to impose on you. You're not to possess any firearm, destructive device, or other weapon. Sounds like you don't have one in your house now, but you cannot have one in your house. I do that both because of this concern. You seem to want to provoke people to engage in assaultive conduct. That's what I saw. So you should not have weapons. I also am concerned if pretrial needs to visit your home. You know, it is the national standard. DC doesn't have home visits. Other jurisdictions do. Arizona does. They may in the future for you, as soon as the pandemic is over, which is hopefully soon. So you can't have any guns in your possession or in your home. The one good thing I saw about the video is you did seem to be concerned that you were on release. At one point you said you didn't want to actually get in a fight. You wanted to avoid that because you knew that that might have consequences in this case. So that was smart. But hopefully those two conditions, especially the one that says you've got to report any context to law enforcement, will help you remember that you were on release in this case. I'm not going to prohibit you from YouTube videos, making more videos at this time. I will certainly be reading closely any future reports from pretrial about contacts with law enforcement, other incidents that they think indicate your danger to the community. I don't think I'm willing to change either that condition yet or put you back under house arrest. But I will do that. If you violate the law in the future, if you engage in a fight in the future, you're arrested in the future, I will certainly consider strongly putting you back under house arrest, or in an appropriate case, having you detained pre-trial.
Yes, Your Honor.
Do you have any questions?
No, Your Honor.
All right, I will be issuing an order which will reflect the decision of the court here. Again, Mr. Giannett, you should feel free and you should call the police. And so I'm not doing this because you called the police that night. It was the conduct that led to the assaultive conduct, which required you to call the police, is what I'm focused on. I also encourage pretrial to let the court know about future similar events like this one. I don't have any problem with pretrial raising these issues with the court. I'll be looking closely at this case in the future if such reports are submitted. Okay, that's the ruling of the court. I'll issue an order changing your conditions of release as reflected. Part of
Your Honor, may I just get one point of clarification?
Yes.
So it's not a violation of the conditions if he does have additional contact with law enforcement.
No,
But
it's
it was-
just that he's got to report that to pretrial. So every time you have a contact, whether it's just questioning, stop, you need to immediately report that to pretrial.
Calling the cops, that's a prank. Law. I know. Thank you, Your Honor. I don't believe there's anything.
I don't know what that was all about, calling the cops for a prank. Any questioning, any contact with law enforcement, you need to report it.
Let me clarify, Your Honor, since you heard part of that. So what happens is that on his streams, oftentimes people, again, because he has fans and he has people who don't like him very much, people who don't like him will follow his stream, and then they will call the cops and they will say things. They'll make false reports essentially to law enforcement. Then law enforcement comes to wherever he's at, and they believe that, you know, he's done something lewd or he's done this or that he hasn't, but then he ends up inevitably having contact with law enforcement.
Then he'll need to report it.
Yeah.
That's right. You need to report that to pretrial, and they can decide what to do with that. He can report it with explanation, and they can decide whether or not to raise it with the court or not.
Thank you, Your Honor.
Okay. Parties are excused.
Thank you.
Remove me off the network!